Subject matter jurisdiction. Federal courts must have authority over the claim in question, as opposed to the parties or property, which is in concern of personal jurisdiction. Subject matter jurisdiction refers to the court's ability to exercise that authority. The Constitution provides limits on the type of cases that federal courts can hear. Subject matter jurisdiction cannot be waived. So types of subject matter jurisdiction are 1, diversity, 2, federal question, 3, supplemental, and 4, removal. By contrast, state courts are presumed to have subject matter jurisdiction in a narrow set of cases. Federal courts have exclusive subject matter jurisdiction, such as in patent or infringement. Diversity jurisdiction. So federal courts have subject matter jurisdiction over controversies between citizens of different states, even when the claims do not involve federal law. So this is diversity jurisdiction conferred by Constitution and by statute. The requirements for diversity jurisdiction are 1, complete diversity. So every plaintiff must be of a diverse citizenship from every defendant. So no diversity in any plaintiff is a citizen of the same state as any defendant. It does not require that all parties be citizens of different states. Just no plaintiff and no defendant can be from the same state. So 2 plaintiffs can be from Utah as long as no defendant is from Utah. So examined at the same time of filing, diversity need not exist when the claim arose. Diversity can exist between citizens of a U.S. state and a foreign country, sometimes called alienage jurisdiction. And then 2, the amount in controversy must exceed $75,000. Plaintiff must make a good faith allegation that her claim is in excess of $75,000. Exceptions to diversity jurisdiction: federal courts will not hear actions involving divorce, alimony, child custody, or probate, even if diversity requirements are otherwise satisfied. So citizenship for complete diversity: every plaintiff must be diverse citizenship from every defendant. Determining citizenship for diversity purposes varies for individuals and businesses. So for natural persons, citizens of the state where they are domiciled at the time the suit is filed. A domicile is where a person was last both present and intending to remain indefinitely. A person always has one and never more than one domicile. If your domicile until you have a new domicile. Factors for determining a person's domicile: look for a physical actual presence in the state and mental intent to make the state a permanent residence. So where the person votes, works, is licensed, etc. For a business, corporations, citizens in every state where incorporated and where the corporation maintains its principal place of business. So a corporation can have multiple states of citizenship. Determining where the principal place of business, we have to look at where corporate decisions are made. So we call this the nerve center, usually corporate or headquarters. For unincorporated businesses, we call these LLCs, LLPs, etc., citizens of all states in which any partner or member is a citizen. Amount in controversy. So a plaintiff's complaint must make a good faith allegation that the amount of damages or injury in controversy exceeds $75,000, excluding interest and costs. So this is the lenient standard to dismiss for insufficient amounts. There must be no legal possibility that recovery will exceed $75,000. The amount actually awarded is irrelevant. Equitable relief claims. Courts look at the value of the harm caused. They can look from either plaintiff or defendant's perspective. It does not require injunctive relief, harm a plaintiff by more than $75,000, or it would cost defendant more than $75,000 to comply with an injury sought. So aggregating claims may be permissible to meet the $75,000 requirement if one plaintiff can aggregate all her claims against a single defendant, or if multiple plaintiffs or defendants, aggregating only allowed if either one plaintiff has joint liability claims against multiple defendants, so we use the total value of the claim, or two multiple plaintiffs seek to enforce a single title of right, which they have a common individual interest, which is rare. Several plaintiffs only jointly own real estate and sue defendant to quiet title, undivided interest, so we aggregate, and that's okay. Next, we have federal question jurisdiction. Federal courts have jurisdiction over properly pleaded claims arising under federal law. There is no diversity or amount in controversy requirements. The requirements are that the claim must show a right or interest founded substantially on federal law. Federal question must appear on the face of the complaint. Federal question jurisdiction cannot arise based on extraneous allegations or potential defenses. Analysis. Ask if plaintiff is enforcing a federal right, one that arises under federal statute, regulation, constitution, etc. If not, federal question jurisdiction exists. Note, beware of fact patterns in which a plaintiff raises a federal law or issue, but plaintiff is not enforcing a federal right. Exclusive federal jurisdiction. Federal courts have exclusive jurisdiction over certain types of claims which may be heard in federal court. Otherwise, federal claims can be heard in state court, which are courts of general jurisdiction. Most common areas of exclusive federal jurisdiction are bankruptcy, patent, copyright, and trademark, federal antitrust claims, and postal matters. For supplemental jurisdiction, it allows federal courts to hear additional claims, like counterclaims or cross claims that do not on their own meet diversity or federal question jurisdiction requirements. Cannot use supplemental jurisdiction to get a case into federal court. The requirements, the common nucleus of operative facts. Each additional claim must share a common nucleus of operative facts with an existing claim that invoked federal question jurisdiction or diversity jurisdiction. So the same transaction or occurrence. Supplemental claims share a common nucleus of operative facts if they arise from the same transaction or occurrence as the underlying claim. Discretionary refusal. Courts may refuse a supplemental claim if A, original jurisdiction claims are dismissed early in the proceeding, B, supplemental claim raises a novel or complex state law issue, or C, supplemental claim substantially predominates over original jurisdiction claims. Limitation. In diversity cases, plaintiff cannot use supplemental jurisdiction to overcome lack of diversity. Does not apply to defendant. However, plaintiff can use supplemental jurisdiction to overcome insufficient amount in controversy. Removal jurisdiction. Defendant can remove a case originally filed in a state court to federal court if the federal court would have subject matter jurisdiction, like diversity or federal question jurisdiction. Removal rules are: 1, can only remove if the case could have been filed in federal court. 2, only defendant can remove, all defendants must agree to removal. 3, can only remove if federal district embracing the state court in which the case was originally filed. 4, defendant who files a permissive counterclaim in state court waives the right to remove. Timing is that defendant must remove within 30 days of service of the first removable document, usually a service of process, and the procedure is that defendant must file notice in the state and federal courts. Notice must contain grounds for removal and copies of documents served in state court. It must be signed. All adverse parties must receive notice of removal. Diversity jurisdiction limitations are that defendant cannot remove if plaintiff filed suit in any of defendant's home states. No removal if defendant is a citizen of the forum state. Remand. If removal is improper, court can remand a state court. Improper procedure, plaintiff can move to remand within 30 days. Lack of subject matter jurisdiction, plaintiff can move to remand at any time. Regarding the Erie Doctrine, in diversity cases, federal courts must apply the state's substantive law and federal procedural law. Use the below analysis to determine if the state or federal law applies, whether a state law is substantive. The analysis is 1, is there a valid federal law? So like a constitution, federal statute, rule that is on point and directly conflicts with the state law. If yes, apply the federal law. If no, federal law is on point, analyze under the following tests. A, outcome determinative. Would applying or ignoring the state rule affect the outcome of the case? If yes, the state law is substantively and should be applied. B, balance of interests. Does either federal or state systems have a strong interest in applying its rule? If one has a clearly stronger interest, apply that law. C, forum shopping avoidance. If federal court ignores a state law, would it encourage litigants to flock to federal court? If yes, state law is substantive and should be applied. The following will always be governed by state substantive law. 1, the elements of a claim or defense. 2, statute of limitations. 3, conflict choice of law rules. Or 4, rules for tolling or statute of limitations.